Hello. Hello, everyone. And good morning or good afternoon, whatever time zone you're in. Today we're going to be covering the Tyler Robinson hearing. I don't know if I think it's Webex and I think it's audio only. So it might be quick, but we're just going to have a discussion before and after because we don't know what's happening. Right. So my guest today is Greg.
Hello.
And yes, you can tell them who you are again and your social media handles and what you're going to, you're going to help me today because
Yeah,
you know a lot about this more than I do. So go ahead.
yeah, I did a bit yesterday about it, and obviously I've been looking into it. Well, I've been covering the this process generally, but I did some time on this specific motion. So yeah.
Great. Thank you so much for coming. So today, and my partner Chris is here today. You can go follow him at Allie Files Research, right?
Yeah, AllieTopFiles
Team.
Research Division. But please follow Allie and Greg. I am just a martini shaker. That's what I do for these two fine individuals.
So where can they find you, Greg?
At the Entheogenic ENTHEOGENIC Esquire YouTube channel. My name, my handle. It's right there, and then my name is Greg, so it's dash Greg on the screen there. So.
I watched your last one; it was really good. Your court coverage was really good.
Oh, thank you.
So today, explain what's happening because when it comes on, we can't talk, right? So we'll try to talk afterwards, but explain what's happening today.
So today is the judge is going to be giving an order. So, and we're not really sure exactly how long or what it's exactly going to consist of, but we know for sure that judge is going to be issuing an order. The defense filed a motion back in January seeking to have disqualified the entire Utah County Prosecutor's Office. And the basis of the motion is that the Chad Grunander, which is an attorney second in command there at the Utah County Prosecutor's Office, had a daughter that was at the event. And so what the defense is alleging is that because his daughter was there and there's that kind of emotional tie to the incident, that he's not going to be able to be without bias or prejudice against Tyler Robinson, who they're alleging committed the crime, and ultimately will be making prosecutorial decisions. For instance, they claim that the death penalty, it was announced and noticed pretty early on, right? And so that's kind of evidence the defense is using to say, hey, judge, look, Grunander and his crew there at the office are going really hard on this, seeking, potentially more punitive measures than are, normally sufficient in this instance because of this connection. And then obviously Grunander is potentially conflicted because his daughter's there. And, the argument that the whole office, the defense is saying, well, they didn't come out early on and announce it. And because Grunander has had this conflict and he's second in command and been working the case with all these other attorneys, that pretty much the whole office has been, contaminated or tainted essentially. Right. And so on the counterpoint, the prosecution saying, one, Grunander's, and a lot of it revolves too around her potentially having to be a witness, right? And so what the prosecution is saying is that, his daughter was there. I think they marked it off. She was like 75, 80 feet from where Charlie was sitting at the time. But, magically she was looking the other way. Magically she was looking the other way when it happened.
She was there. She was
yeah,
there.
and
it's a
yeah,
conflict
but
of interest, I think. I believe she was there. So is it a conflict of interest because she would come home and discuss it? Like, I don't know.
Yeah. So, and it really revolves around, well, a little bit was, because obviously if she was traumatized or hurt or put back in some way by this, that would obviously increase the amount of potential bias and stuff that Grunander would have. And so they're alleging that the prosecution's alleging that she wasn't really traumatized. She didn't miss a beat. She still went to classes. She hadn't gotten counseling. And then, according to them, she's not a material witness. So they're not going to necessarily have to use her. And really what was interesting in the larger context is that in the response, the prosecution claims that all the witnesses that were there, that their testimony is only marginally relevant, really just for context, right? And for me, I've been really looking into the destruction of evidence and stuff, and so that's really was material for me, because I'm thinking, okay, if you don't consider these eyewitnesses' testimony to be that important for your case, obviously the forensic and digital and other evidence by implication would be. And so with that being said, you let a lot of that get destroyed and paved over. So, and sorry, I was a little bit of a tangent, but
No, that's great.
yeah, another interesting thing is that on the death penalty, the prosecution's response to that is like, well, one, they basically they announced the death penalty the day after, and I think it was actually the governor, the AG, that formally announced it, but they didn't charge it until about a week or so later, when they filed the actual information against Tyler Robinson. And their argument is, well, that's within the statutory period. It is. There's other cases where it was announced very early on like that. They felt like they had sufficient evidence. And then, they talk about this one case where the prosecutor in Utah, where a prosecutor waited a while to announce it. And, rumors started going around that they weren't going to seek it. And I guess as a prosecutor, you just don't want that, and so they cite that case as saying, well, we announced it early, so that way rumors. Oh, and they also say, announcing the death penalty early helps fight against conspiracy theorists and misinformation. And, that struck me as odd, because I'm thinking, no, regularly on my work or my channel, my subscribers are cheering me on because of the death penalty. They're like, man, they don't want the idea that someone be put to death that potentially is not guilty. And so I disagree with the prosecution in that. I think that announcing the death penalty like that, and I think it's good that does prompt us out here, right, to go and double check, cross all the T's, dot all the I's. And so I found that interesting too. But and then lastly, they say that our DA Jeff Gray, he campaigned on the death penalty. So this is us fulfilling his is really, in my view, my worldview, kind of sick. Some of the stuff that they're arguing as far as like trying to support their decision to pull the trigger on the death penalty. But again, that's just me. But I think it speaks also to a lot of this case, like I pointed out, with them saying, oh, these eyewitnesses, their testimony is only contextual, it's only marginally relevant. And so to me, that speaks that there might be more of an element of bad faith in them covering up the crime scene than what we've kind of been led on. Does that make sense?
Yeah, that's a really good rundown of it. Also, is Utah the only one that can do speedy trial? Like, I was reading about that. And if anybody has a question for Greg, because he's more familiar with the court proceedings and stuff, I'm not an expert at this stuff.
Yeah.
So,
are you referencing like Erica's announcing of okay, so, and just so everybody knows, that wasn't like a formal motion, it was really just a notice, and in a way really senseless. Like, she didn't invoke any kind of like firm constitutional right or statutory right. It was really just a general, the law does recognize that victims have some rights in that, and again, it's not something that's firm in the jurisprudence or anything, and judge did acknowledge that, yeah, there is a somewhat recognized of a right that victims have a right to have this thing speedy. But in all instances, right, the defendant's right to a speedy trial is going to trump a victim any day of the week, right? Because a defendant's right to a speedy trial can be waived in favor of doing more investigation, making sure all the evidence, questioning. And so they're always going to defer to that. I really think Erica's notice was really just a political stunt or move. She even had some out-of-state lawyer, do it for her. Unfortunately, I think a lot of people put a little bit more weight into that. And I actually did a video on it. So I guess guilty a little bit of ways, but it really wasn't like she was invoking some major right that's going to like force the court to move quicker. And optics wise, I think it just looked terrible for her. I'm not sure why, who decided to do that, but I don't think the optics looked very good in this scenario.
She attend? No, she didn't even attend. But we got some questions here. Like, okay, what does he say? Why is he still in custody? Video found with bullet in flight is 3 frame, and it came from above from a drone.
Yeah, I And I get what he's saying. So right now, and Barron misspoke a little bit the other night. He said, there was an indictment. There's not actually an indictment right now against Tyler Robinson. It's what's called an information, and it's really just an affidavit by the prosecutor.
Okay.
And I guess they did that because they wanted to get it done so quick. But apparently, there's supposed to be a preliminary hearing in May. And now that preliminary hearing will be, if it occurs, should be the hearing where the probable cause is tested, and the prosecutors need to show up if it's going to be contested and get ready to establish probable cause. And now, in the current climate, it's my view that that's going to include them getting the medical examiner up there. They're going to need to release the autopsy report and all that stuff to firmly establish it. So it'll be very interesting to see how this all progresses up until that point. And one other thing I'll say is that the defense currently has a series of motions in front of the judge, which I think he's going to speak about proceeding on those today. I mean, not that he'll rule on them, but what's the schedule? But yeah, they're trying to keep pretty much all the pretrial evidentiary type motions private. And then, as most people are already aware, they're trying to keep cameras and all that stuff out of the courtroom. And kind of the double whammy there, as pointed out by the media, is that they want those proceedings to be in private, like the judge even deciding on those motions to be private. So it'll be very interesting today if judge speaks on that, what he's going to decide as far as like proceeding on those motions. Are they going to do that in private, or do everything need to be filed out in the open? Because as a lawyer, I'm looking at them in the filing system, and all I can see are the prosecutors and the media who's actually come in as a party to this case. All I can see are their responses, and kind of infer from that what the original basis of the defense's motion is. They're not very strong, obviously. We have a very strong right, and in this, judge is our advocate. Ultimately, judge is supposed to represent the people and their right to access to the courts. And so I hope he will, fulfill his duty and make sure that we get sufficient access to these things.
Okay, what question do we have? Or it's not a question. The daughter may not have been traumatized, but as a parent, you go through tons of emotions knowing your child could have been harmed.
And let me say this, a very good point. And not only that, if I'm the defense, one thing I want to point out is that one of the aggravating factors that they're using for the death penalty is like the fact that he shot in an area where there's like children and other people at, right? So like the fact that your daughter was within this area that you're claiming causes one of these aggravating factors for the death penalty. I mean, that right there is, if I were litigating this motion, that would be one of the main things I'm harping on.
Right.
Yeah.
Oh, let's see. They're going to be starting soon. So see, they're late, like you said.
Yeah. And again, don't get, this might be very quick. We know for sure that judge is going to issue his order, and I'll speak on that real quick too. Unfortunately, ladies and gentlemen, I do feel that they're conflicted and that they need to get another office to come in for a number of reasons beyond just the conflict too. But unfortunately, I definitely don't think judge is going to disqualify that whole office. If he does anything, he's going to disqualify Grunander alone. But again, we might not even see that. So just a heads up for everybody, just my feelings on it.
Yeah. Well, what is he saying here? Did you read the above in bad faith all the way? Bullet caught on the video in 3 frames from above the drone.
Yeah, I get it. I have. He's had quite a few comments on my videos, and I hear him. I'm not married to any theory on this, right? So and I do appreciate him chiming in, and I have heard that. As a theory, and it's really crazy, right? Because the video can be interpreted in so many different ways. But I think the one thing for sure, in my opinion, that it can be interpreted is that it wasn't 30-06 round, right? And so that's one theory, that it wasn't 30-06 that I am pretty married to at this juncture. And so that's why I've been, leaving space on my channel and in my head for all these different potentials, right?
Mm-hmm. And we're just waiting, guys. They're not live yet, so we're waiting for Fox News to come on here. Debbie, wouldn't a witness that was at the event not be considered? I would think of a witness would be someone who plays Tyler there.
Yeah, who places Tyler there at the crime, I
Yes.
believe.
Oh, who places Tyler at the crime scene? I haven't heard that there is a witness that can. I mean, have y'all heard? I mean, certainly if they had other, eyewitness testimony other than these alleged video clips that we have, I mean, obviously that would bring their case up to a whole other. I mean, just that, you know what I mean, would be helpful for them, right? But if all
Yeah.
they really have at this juncture we're aware of are these, in my opinion, kind of grainy looking crazy videos of someone jumping on a roof or going down a staircase, like that's just, in my opinion, not going to be enough nearly
No.
to get them. And obviously they have other stuff. Let me point this out too. The text messages, there's no timestamps on them. All we're given is like a copy or something like that to look at on in the media. But these text messages between Chad Grunander and his daughter, they're attached to their response in this motion, and it has timestamps on it. Those texts have timestamps, and it looks like the little blips on an iPhone, regular. And so that just makes you think like, well, how come y'all could get these in this manner, but not those,
It's just bizarre. It's bizarre. Even the text messages right from the beginning of Lance, so for me, my question is to you, are they going to show any video footage of anything that day in court?
Are you talking about today or at the trial?
No, at the trial,
well, I mean, they better at the trial. Yeah.
Yeah.
I mean, if they're relying on that video to put Tyler at the scene at that time, then yeah, they're gonna have to place. I mean, if they don't have eyewitness testimony, they're gonna have to do something, to substantiate that, right?
And this is going to be probably a long thing. It's going to run till what? What year do you think this is going to be?
I don't know. And looking back over the last several months at these media stories and stuff, I think the media, and this is just my opinion, my perspective, is like there's been a targeted campaign through the media to reach Tyler in jail to try to scare him into a plea bargain. I did a video not long ago, February 4th, the legislature in Utah, the Republicans, in a major shift in perspective on the death penalty, are introducing a bill that would expedite the death penalty. It would make it appeal proof for the state on appeal, and some other things that's very detrimental to defendants on death penalty. And, considering that it was such a crazy sway from where they were like 3 or 4 years ago in that state on the death penalty, my take is that it's not being introduced because I don't think it would get passed. I think it's introduced so that way Tyler reads that article and starts thinking about whether, he wants to go into this and risk it.
All crazy. What does someone say? Shabbat shalom. Just stop.
Yeah, Shabbat shalom. Daddy's home. Here's my phone, or whatever.
I actually did see a couple interesting comments which we may want to talk about.
Sure.
If you scroll back a little bit there, honey.
Okay, let me just see this one. Is there anything more on Tyler Robinson's defense attorney being related to the camera guy?
Yeah, thank you, Lisette. Yeah, so that was also, and I haven't seen any really something substantiating it per se, but there's a guy named Robert Novak that's actually from California. That's one of Tyler Robinson's defense attorneys. And I've seen a lot of people alleging that he's like either the brother-in-law or in some way pretty directly related to Terrell Farnsworth, who was the guy that, obviously took the SD cards and the camera and stuff right after the incident. Again, I haven't had anything substantiate that, but enough people have been saying it. I'd love to see something, because if that is the case, then there's probably needs to be more than just this discussion about disqualification,
That's something that's been circulating for quite a while. And I don't remember, like you were just saying, Greg, I don't remember if I actually ever seen anything concrete besides people just pointing out a guy standing around in a video of a courtroom going, that's the guy, besides that, I haven't seen anything concrete.
Yeah.
And another interesting comment that I noticed is, where was it now? I think it's back a little bit.
I can go look back.
Yeah, it was close to the one that you just found there. It was actually interesting. Hold on. Camera guy. There we go. There is misinformation being circulated that Tyler Robinson, yes, that's it right there.
Brett Booth.
Yeah, that's interesting. And, we were told that kind of early on. And then when you read through the actual information, it's kind of really convoluted that he like implied to his mother or something like that, which led to, this friend coming over. And there's just a lot of mystery to it. But I can say this is that, trust me, if he would have confessed in a manner in accordance with the Constitution, trust me, we would absolutely know about it. It would be highly material. But I definitely don't think that's the case. I don't. And so, yeah. And again, all we know in the information from my reading is that he somehow implied it to one of his family members, which kind of led to all this.
Ah, okay.
Yeah.
All right. Will any FBI agents be involved with the court hearings for questioning?
I'm assuming that they're referencing like the defense putting up FBI agents, or maybe even the prosecutor. It's potential. Obviously they were involved in this investigation. I think they found the rifle and stuff like that. So to the extent that the prosecution's going to need to put that evidence in, they're going to need to put those agents up who found it and question them. And yes, if the FBI or other agents have questioned Tyler and made any admissions, stuff like that, they would also have to be put on the stand. And so, yeah, I would expect to see some FBI agents at the trial being questioned by both sides.
Okay.
That would make sense. And I'm pretty sure we're not going to see those people's, if they're going to testify one way or another, until we actually get down to the trial itself. I couldn't see anybody wanting to tip their hand in advance on what kind of evidence they may have. Would that make sense?
Yeah. And so really at this juncture, beyond the evidence that we kind of have out here in the public record and that's referenced in the information, all we're going to be able to get is stuff like for instance, in the last hearing, the defense lawyer asked the state investigator about the DNA on the gun and implied that there were like 5 different DNAs on the gun. So it's like the pretrial motions and hearings, like if they're made public, right, we'll be able to get tidbits through that. For instance, the defense has already filed a evidentiary motion, and we're really unsure exactly what evidence it relates to. The motion's been labeled private, but we know of it because the media filed a response, challenging the fact that it's private. And so, again, I think Judge is going to speak on how he's going to proceed with those motions today. So it'll be very interesting.
I already read that one. Hold on a second. Who's this? Greg caught you that when he was live. I don't know.
Hey, what's up, Robert? Good to see you, brother. That's one of my good.
Oh, okay.
Yeah, I've got a good group of subscribers. I'm very, very fortunate and blessed. We've got a good group.
That's amazing.
Yeah.
Okay, there are 3 cameramen at UVU that day. Anyone/FBI asked them to hand over the yes. I agree.
They said they were asked to hand it over, but did we actually see that? Has that been confirmed?
Right.
No.
Nobody saw anybody hand anything over. Let's just clear. And I interviewed Henry Dells because he said he saw it, and then he said, I don't think I saw it. Somebody told me that Terrell there was 3 SD cards. He handed it over to the FBI. Well, the FBI wasn't even there yet. So, and the kids were
definitely not that day, because you remember, I would assume because Candace was able to watch some of the video from FaceTime on the cell phone. Now, they said they streamed it, so perhaps he had recorded it through the stream and had turned over that SD card. So that is a possibility, right? It certainly is. But I have seen nothing to confirm from an independent third-party source that he actually has indeed handed those cards. Because regardless of whether it was recorded on stream, those physical SD cards are very important. And I would almost want to also forensically examine the cameras as well.
Same.
If I were a defense attorney expert, yeah.
Another interesting fact was, if you remember, it was mentioned right at the beginning within the first week, maybe even just before that, our friend, Mr. Patel, had actually liquidated a lot of the agents. You remember that? So that's
Yeah, it's funny you say that. I was looking at the Who Killed CK website last night, and that was like one of the first things on their timeline. I had heard that way back when, but just reminded of it last night. Sure did. It was like late August, I think, whenever that occurred.
That's very convenient. And then they had to fly in experts because I think they gutted the whole field office there.
Mm-hmm. So more or less, yeah.
I remember hearing them saying, I thought, and I could be wrong, people coming in from like Jersey, Boston, New York, like they had to fly in agents.
Mm-hmm.
So how did Tyrell give it to an agent on the day?
Well, that's the thing, is that he should have never touched it in the first place, right? And so based upon what I saw when he was taking it, just my impression, it didn't look like he was in a hurry to run and hand it over to a police officer, because the chief of UVU police was, I think, like right there in the vicinity when he did. Right. So that would obviously be the first person, if you're going to do something, in my opinion, stupid like that. I mean, that'd be your best move. If you're going to do it, it's like go and try to find the highest ranking official you can ASAP to hand it over and beg for forgiveness.
There's going to be some more comments. If they say Tyler is guilty and they put him in witness protection, switch him out, then this case is closed and the person's responsible. Get away with it. Like maybe they planned on doing this. Yeah. Anyways, they probably did. I don't know. Allegedly.
I actually want to add something to that.
That's a very good comment.
Well, we're literally seeing this happen right now, guys. Like, think about that last comment. Now look at the photos of Ghislaine Maxwell they're putting out now.
Mm-hmm.
Right? Mm-hmm. Think about that last comment about swapping someone out. And now look at what we've been shown about Ghislaine Maxwell. Is that her? I don't think so. A lot of people say it looks like a little.
Oh, here we go, guys.
Personnel.
Oh, here we go. Here we go.
That Mr. Grunander's child had attended the rally. No effort was made by the Utah County Attorney's Office to screen Mr. Grunander from the case or from speaking about his child's experience with other attorneys in the office. Mr. Gray consulted with his prosecution team, including Mr. Grunander, when determining which charges to file and whether to seek the death penalty. But the ultimate charging decision rested solely with Mr. Gray in his statutory capacity as elected county attorney. He made the decision to file a notice of intent to seek the death penalty at the inception of the case rather than waiting until after the arraignment, as allowed by statute. His decision to seek the death penalty was based upon his assessment that the death penalty is appropriate in this case. He chose not to wait to file the notice because he believed it would cause unnecessary speculation on the part of the public and angst on the part of the victim's family. Waters' presence at the rally did not materially influence Mr. Gray's decision-making, and the court finds that this conclusion is supported by credible testimony and objective record before it. Approximately 3,000 people attended the rally at Utah Valley University. Throughout the course of the investigation, over 40 attendees voluntarily provided witness statements to law enforcement, and several attendees provided video footage of the incident. No evidence was provided by daughter that she was not available from other sources. The state has chosen not to call her as a witness in support of its prosecution of Mr. Robinson. In October 2025, Mr. Grunander sent an email to defense counsel and disclosed his child had attended the rally at Utah Valley University, where Charlie Kirk was shot. Defendant moves for disqualification under Rule 1.7 of the Utah Rules of Professional Conduct, which provides in relevant part that a lawyer has a concurrent conflict of interest if there is a significant risk that the representation will be materially limited by a personal interest of the lawyer. In applying this standard, the court is mindful that this is a capital case. The decision whether to seek the death penalty is among the most solemn exercises of prosecutorial discretion, and allegations of bias or personal influence in that context warrants careful and searching judicial review to preserve both due process and public confidence in the integrity of these proceedings. Defendant argues that Mr. Grunander's relationship with daughter creates a significant risk that his decision-making will be and has been materially limited by personal interest, namely his loyalty to his daughter. Because no screening was in place to prevent Mr. Grunander's conflict from tainting the entire prosecution team, defendant argues that Utah County Attorney's Office should be disqualified from prosecuting this case. This is especially so because Mr. Grunander holds a supervisorial role in the office and is a key part of the prosecution team. Defendant has not identified binding authority establishing that a prosecutor has a concurrent conflict solely because the prosecutor has a familial relationship with the potential witness, particularly where the witness has no unique relevant information. In the cases defendant cites, the prosecutors were split between their loyalty to the government and their loyalty to the defendant, or a personal interest separate from the case being prosecuted. In State v. McClellan, the prosecutor had previously represented the defendant and had access to confidential protected information, which could undermine the defendant's right to due process. In State v. Balfour, the prosecutor had past financial, business, and political ties to a defendant, which could conflict with the prosecutor's duty to pursue justice and represent the government. In Wright v. United States, the prosecutor's wife was the defendant's political opponent whom she had accused of sending people to assault her. In State v. Tate, the prosecutor had been a judge on the defendant's case and had been privy to ex parte communications. In People v. Connors, the prosecutor was both a victim and a witness to a separate crime committed by the defendant, which created a personal grudge against the defendant himself. Each of these cases involve a personal interest directly connected to the defendant or some other interest that materially limited the prosecutor's representation of the state. By contrast, the record here contains no evidence that Mr. Grunander or any member of his family had a personal relationship with, bias toward, defendant, nor does the record show that Mr. Grunander's professional judgment has been or is substantially likely to be materially limited by his loyalty to his daughter. Speculation regarding potential influence is insufficient to establish a significant risk under Rule 1.7. The court has independently reviewed the evidentiary record with particular attention to whether any direct or indirect decision-making in this case reflects personal involvement inconsistent with the objective prosecutorial judgment. The court finds no such evidence. Defendant argues that two prosecutorial decisions could have been impacted by Mr. Grunander's relationship to daughter, thereby affecting defendant's due process rights. The decision not to call daughter as a witness and the decision to seek the death penalty. The court is persuaded by the evidence presented that daughter is not being called to testify because she has no uniquely relevant testimony to give, and the state has access to much stronger evidence from other witnesses. To the extent defendant believes his due process rights are violated by the state declining to call daughter as a witness, defendant has subpoena powers and a right to call her himself if he believes her testimony is important to his case. As to the decision to seek death, the court finds that daughter's presence at the rally did not factor into the prosecutorial analysis. The evidence supports that Mr. Gray's decision was grounded in his assessment of the facts and applicable law. Because the circumstances of every case are unique. Oh, I heard something. I'll continue. Let me start over on that sentence.
Wasn't me.
Because the circumstances of every case are unique, prosecutorial discretion allows a prosecutor to consider a host of relevant factors when determining whether to seek death, as long as the considerations of those factors is constitutionally sound. Even if Mr. Gray considered the impact on daughter when deciding to seek death, defendant has not shown that the impact of the crime on victims, witnesses, or even prosecutors themselves is an unconstitutional consideration when deciding to seek the death penalty. In sum, the court concludes that there is not a significant risk that Mr. Grunander's loyalty to daughter has or will materially limit his representation of the state of Utah. Furthermore, defendant has not shown that there is a significant risk that Mr. Grunander's relationship with daughter has or will impact defendant's due process rights. Based on the record before the court, defendant has not shown that his prosecution by the Utah County Attorney's Office is tainted by a concurrent conflict of interest under Rule 1.7. During oral argument, defendant requested the court also consider whether the Utah County Attorney's Office followed the process recommended by the Utah Prosecutors' Best Practices created by the Statewide Association of Prosecutors, otherwise known as SWAP, in determining whether to disqualify the Utah County Attorney's Office. Defendant argues that best practice demands that a prosecutor avoid the appearance of bias based upon public perception. To avoid this appearance, the Utah County Attorney's Office should have immediately screened Mr. Grunander from the rest of the office. Because it failed to do so, there is now a hint that the decision to seek the death penalty was an emotional response to Mr. Grunander's concern for his daughter. The best practices document is not controlling on this court. And even if it was, the court is unpersuaded that Mr. Grunander's relationship with daughter creates an appearance of bias in this case. Prosecutors need not be immune to the emotional response of others to prosecute a case. Indeed, it is part of a prosecutor's duty to interview witnesses and victims and evaluate the impact of an alleged crime. A prosecutor need not be disinterested on the issue whether a prospective defendant has committed the crime with which he is charged. If honestly convinced of the defendant's guilt, the prosecutor is free, indeed obligated, to be deeply interested in urging that view by any fair means. True disinterest on the issue of such a defendant's guilt is the domain of the judge and the jury, not the prosecutor. And this is citing from Wright. Also, prosecutors need not be entirely neutral and detached. In an adversarial system, they are necessarily permitted to be zealous in their enforcement of the law. After reviewing the record, the court concludes that the familial relationship at issue, without additional evidence of personal involvement or influence, does not create a reasonable perception that the prosecutorial discretion was exercised for improper reasons. Zealous advocacy remains bound by constitutional and ethical constraints, and the court finds that those boundaries have not been crossed here. This ruling is confined to the specific facts established in this record. Different circumstances, such as evidence of direct personal involvement, uniquely material testimony, or demonstrable influence over discretionary decisions, could warrant a different result. In sum, the defendant has not shown that there is a significant risk that Mr. Grunander's loyalty to daughter has or will materially limit representation of the state, nor has defendant demonstrated that his due process rights are compromised by the continued prosecution of this case by the Utah County Attorney's Office. Applying this governing legal standard to the facts established in the record, defendant's motion is respectfully denied. All right, that order in a written form will be available shortly online. The court wishes to turn to its last matter, and the court wishes to address the remaining outstanding motions in a timely manner and to set appropriate dates for their hearing and resolution. The court recognizes that coordinating schedules can be challenging and that we all make a good faith effort to accommodate the court and one another in setting these matters for hearing so that the constitutional rights of all parties are protected and preserved. Counsel, I'm reviewing a list of motions before the court, and so I wish to quickly address that, set hearing dates so all parties have an expectation of what comes next and what to prepare for. And so I'll turn to the attorneys. The court has thoughts, but I want to hear your thoughts first.
Judge, this is Mr. Grunander. I apologize for my camera. Something's happening with it this morning, but
Sure.
I see that the court entered a couple of rulings that we received late last night. I think there are still the outstanding motions to classify as private that need to be addressed. And then there is the outstanding motion from the defense to exclude media, electronic media coverage. And there is a request, and I'll defer to the defense, but there's a request for an evidentiary hearing there. But that's what I see as far as what's outstanding. In addition, Your Honor, I should say there is one with respect to a piece of evidence that we're trying to identify additional reports on to get to the defense so that we can be fully prepared to address that issue.
All right. Thank you, Mr. Grunander. Turning to defense.
Thank you, Your Honor. This is Richard Novak. I know that the court may have seen the emails which were exchanged with the court's clerk and counsel concerning scheduling. We had all suggested a date that the court was available to resolve the classification issues, some of which, as Mr. Grunander said, are still pending, notwithstanding yesterday's orders, and that was the date of April 17th. It was our expectation that the court would take care of the classification issues at a hearing that afternoon. The court's public order yesterday did address in a footnote a question of the media's standing with respect to, say, the merits of the motion that Mr. Grunander mentioned. So we think that that needs to be addressed because the media did file what they purport to be a preliminary response to a motion that is presently classified. So before we actually before the court conducts the hearing on the merits of the motion to exclude, which we anticipate would be an evidentiary hearing with both exhibits and witnesses, we think that it would be most efficient for the court to lay the groundwork on what will be public, what will not be public, and which entities, I'm not going to say parties because that's not right, which entities have standing to weigh in on that motion and the scope of that standing. And we do think because, the court has obviously seen, because it approved the filing of the initial motion, that there's an extensive evidentiary presentation that's necessary. It's not going to be the 2 to 3 hours that we were told the court is available on April 17th. So our thought is that we would have all of that sort of preliminary and standing, all of the preliminary and standing issues resolved at the court's next availability that worked for counsel, which is April 17th, and that at some date after April 17th, we would then have the hearing on the merits of that motion.
All right. Any other?
Does that make sense, or did I just muddy it up even more?
No, I understand what you're saying. Any other input from any of the other parties before the court gives its input?
Judd. I think Mr. Novak mentioned the afternoon of April 17th. I think the court's availability may be that morning. And other than that, I think this plan sounds good and makes sense to the media. I think the remaining issues that are most likely to be argued and resolved at an April 17th hearing are individualized motions related to closure of things on the docket. In that way, there's kind of a commonality between those. There's likely some overlap, even though they're separate briefings, on the interests and the questions related to those motions to classify. I'll note that more may come along. There was a reply to the motion to exclude cameras from the courtroom that has also been subject to a motion to classify. But again, I think that could be argued easily alongside the pending motions to classify or close that the court is attempting to schedule for hearing now.
All right. All right, so here's the court's input. I wish to address the motions to classify and addressing the closure of the hearing or the evidentiary hearing to exclude media well before April. And I don't believe that those hearings will take a lot of time. And for this court, for many reasons, and because the court intends to keep the May preliminary hearing. And I realize that there may be things that come up that may affect that, but as we stand today, that preliminary hearing date is set. And I wish for these issues to be addressed prior to the preliminary hearing, given the nature of that hearing. And so there is clarity on what will happen. What dates do we have available in March? In council, before I get these dates, I recognize that you all have challenging schedules, but this case must have priority as this court is trying to balance the constitutional rights of all parties and being timely in its process. So I ask you respectfully to do your best to ensure that we can align to a schedule that allows us to move forward in a proper manner while respecting the constitutional rights of all parties. And so looking at March dates, I have March 13th. It's rare, available all day. And I want to preface this by saying, just to give you an idea, when I am setting a hearing for an hour or more, I am looking into June just because of the court's calendar. And so this is a rare opportunity to have this to address the motions to classify and potentially closure. What does that look like for the parties?
On the 13th.
Thank you.
Your Honor, I think, this is Richard Novak. I think, and I would defer to Mr. Judd, but I think one of the attorneys of record for the media entities had a problem with March 13th when the clerk initially floated that date, but I may be wrong about that, and then I can address the defense's availability on that date.
Well, I wish to address defense's availability first.
Okay. So I thought that I needed to be on the East Coast for a personal matter. I could probably work around that. The only other conflict we had was that Ms. Visser was scheduled to start a serious felony matter the following Monday morning, the 16th. But we hear what the court's saying. So I can adjust my personal travel schedule to accommodate the court. And I appreciate that the court wants to take advantage of this rare vacancy in its schedule.
Right. Thank you, Mr. Novak. I appreciate that. Mr. Judd.
Your Honor, does the court have a view right now as to whether this would be an in-person hearing or something that could be argued by Webex?
I will accommodate the parties, and of course, turning to defense, and their preference is important, whether they request in person or via Webex, or maybe it's mixed. Maybe some of us appear via Webex. Well, not the court, but the rest of us. So I am open to try to find a solution.
I'm curious about that, Your Honor, but it's not outcome determinative. We will make it work. We realize we're guests in the court, that these issues are important. We recognize the interests that are in play. I'm scheduled to be elsewhere in Chicago that day. I'll appear by Webex if that's what the court allows. If not, then I'll move those plans. This is a priority, and if that's the time that it works, then we'll make it work.
All right. So the parties, first, is it the intent to be in person? And if so, what are the thoughts about Mr. Judd appearing via Webex?
Your Honor, the state is open to any procedure that will allow us to have this hearing on March 13th. We can be in person or via Webex, and we have no objection to other entities, representatives appearing in whichever way is most accommodating for them.
All right. Thank you, Mr. Ballard. Mr. Novak.
All I would say is that if the court is going to open up a Webex for some participants, we will be there either in person or by WebEx or both, because there are, as Your Honor knows, a few of us. Ms. Nestor will not be present because she's already engaged in trial in another county. But we will, I guess what I would say today is that we will be appearing in person, present in court with Mr. Robinson with us. If there is some reason why one of us needs to appear remotely, then we'll address that with the court.
All right, thank you, Mr. Novak. So it sounds like we're going to go ahead and set this in person. I realize that, you know, there are complications, and Mr. Judd, it looks like there is no opposition to you appearing via WebEx. And of course, as mentioned by defense, there are certain attorneys that may need to appear by WebEx. So we will accommodate that, and we'll anticipate Mr. Robinson's appearance in person on March 13th. Counsel, given the direction of the court dealing with closure and classification of motions, how much time will you need to conduct your business in court? I want to open that up and lock it down before that date gets cannibalized by other important hearings as well.
Your Honor, this is Mr. Ballard. I guess I would defer to the defense. It's their motions to close and to classify. But I think having a time limit regardless would be helpful.
I'm going to suggest that, Your Honor, that it's going to be more than 1 hour and maybe less than 2 hours. And the reason why I say that is there are multiple motions to classify around the same issues, which are the motion, the reply, and the evidentiary hearing itself. And the court's going to obviously hear not only from the moving parties, which is Mr. Robinson, but the state and counsel for the media. And it would be hard for me to imagine that many attorneys in the court could do all that in less than 1 hour.
Are you commenting on the amount of time attorneys talk?
Only myself. I'm only referring to myself. Your Honor.
No worries. I include myself in that comment. All right. So let's go ahead and set aside 3 hours just to be safe. I don't want any party to feel pressured, but as mentioned by Mr. Ballard, I believe that setting a timeline is appropriate. So let's go ahead and start. How does 10 a.m. on March 13th look? 10, 11, 12, concluding at the 1 o'clock hour.
That's fine for the defense, Your Honor. That might actually allow me to get to my originally planned destination the same evening.
All right. To Mr. Ballard?
AM is perfect, Your Honor. Thank you.
All right. And Mr. Judge?
Yes, Your Honor.
All right. Let's turn to the second issue where we have that, I believe it was April 17th date. Does that allow sufficient time to address the evidentiary hearing being requested?
In terms of preparation for April 17th, yes. If that's when the court wants to do it, we will be ready to go on that date. That is, if that's what the court means by sufficient time, yes.
All right. And how much time, Mr. Novak, do you anticipate needing? I certainly want to make sure that all parties have enough time to present what they need to present.
Your Honor, I'm going to defer to Mr. Burt on that, if Mr. Burt is able to do so. Looks like technologically he is.
Good morning, Your Honor.
Good morning, Mr. Burt.
Judge, I think on that, because it is going to involve the presentation of extensive exhibits and also some expert evidence, that we'd be looking at a full day, accounting for cross-examination by all the lawyers involved here.
All right. And to the state, what's your input?
A is more than enough to be able to address those issues.
All right. And to the state. I'm sorry, I just, to any other party.
I will defer to parties, Your Honor, on this. As the court knows, we haven't seen the motion itself or the reply. We've seen the state's opposition. But I think whatever the defense believes is necessary, given that they are the party bringing evidence and the expert, if they believe that a day is sufficient, we see no reason to push back on that.
All right. All right. I do note that we have other issues on that day. I think we're just going to have to bump them. And so we'll go ahead and set aside the full day on April 17th. We'll start at 10 a.m. and conclude promptly at 5 p.m. if needs be. But it is the intent that we fully address the issues and it's not carried over or continued to another day. The court anticipates, given what's presented, has been the practice of the court, that it would take it under advisement and schedule a Webex hearing to issue its decision. All right, so April 17th, starting at 10 a.m. I'm assuming in person, and Mr. Novak, I don't want to assume anything. In person with Mr. Robinson in court?
Yes, Your Honor, exactly.
All right. All right, thank you, counsel. I really appreciate your working together, and I know it's complicated. You all have busy schedules. Is there anything else that the court needs to address at this time?
Thank you.
Nothing on behalf of Mr. Robinson at this time. Thank you.
Nor from the media, Your Honor.
All parties, I appreciate your hard work and your efforts, and we will be in adjournment until March 13th. Thank you. Court is now in recess.
Okie dokie.
Well, pretty much as I expected, as far as the, his ruling on the disqualification.
Are they going to come back or?
Yeah. So now he's ruled the prosecutors will continue on. No one or their office has not been disqualified now. So they're going to represent the state. And then from the way I'm taking it, March 13th is going to be over whether the media has standing to object to the classification of the motions, and then obviously the camera thing. So I'm not sure on the 13th if he's going to rule on that might be the motions private. So that might be the day where he determines whether the media has standing to object to these motions being private. And then I would assume maybe he'll rule on it that day or soon thereafter. And then I think the 17th is for the cameras in the courtroom.
Okay.
Yeah,
and that's a full day. That is a full.
That's
day.
going to be a full day. Yeah, they apparently the defense has experts and everything lined up. And I think too, to be honest with you, they're trying to have that private too, that motion and that hearing. And so I guess on the 13th, we'll know whether judge is going to order that all that be released and then give us all the information related to the media motion. So I guess there's in the defense's motion for the cameras as well. I guess there's some type of evidence or something that I guess maybe occurred out here that they want to talk about, but not give any indication. Very interesting. So yeah, it'll be a lot.
Can you explain to people, while this was going on, people didn't know who the daughter was. Can you explain in a nutshell really quickly what that was so people are updated?
Yeah, so the daughter, they're talking about Chad Grunander, who is second in line, from my understanding, at the prosecutor's office there. He has, I think, an 18-year-old daughter who is a student at UVU and who was there on the day. And again, the whole basis the primary basis of the defense's motion to exclude the office or disqualify them was that she was there, she attended. Obviously, her father being second in command, the prosecutor's office, that emotional connection was going to have a negative impact on the way that they prosecuted the case.
So there you go. If anybody, a couple people were asking that. So great.
Yeah.
Way better than me.
Well, and I think the saving grace for the prosecution here was the fact that there are so many witnesses and that indeed they don't necessarily need to use them. And then, like Judge said, it is true that, the prosecutor can consider other people's trauma when making charging decisions and stuff like that. So it's kind of like, how do we assess whether this was him, upset because of other people's trauma, or his daughter who claimed to not even have any? And so I'm not surprised at the court's ruling at all, even though I don't like it. I don't like the way that they handled this case. And a lot of it has to do with the fact that they let the crime scene just get completely trampled over. And, the only way I'm able to really explain that to myself in my mind is that they allowed it to happen,
Yes.
Yeah.
In other words, Erica wants us to hurry, so let's hurry up and get and bury the Patsy. Maybe, yeah. Allegedly.
Yeah, it's like I say, it was pretty incredible to me that she had her lawyer file that notice. A third party outside lawyer filing a very crazy. I mean, I haven't met a lawyer that had seen one yet, something like that filed. And so, I can't believe that they did. They're just not a good look. And it's not like she really moved the ball any. Like I said, there's like no firm substantive right per se of a victim to actually have that big of an effect on the speed of a trial. It seems to have been done purely for show, in my opinion.
Mm-hmm.
And I think that was probably the wrong thing to show, in my
opinion.
Yeah,
well, and the way that we had already been out here talking about the case, I mean, surely they knew that something like that was going to factor into us thinking, they're trying to just cover all this up and get Tyler, down. They couldn't have ever thought that was going to help that whole situation, right?
So, classified aspect of a request to withhold the media sounds about right.
Yeah, so they what the defense is, the classification that they're talking about are the motions that the defense is they filed at least one, but the pretrial evidentiary motions, the defense wants to classify them as private, so that way the filings and presumably the subsequent proceedings would all be, we wouldn't be able to look at any of that. And so I assume that's going to be dealt with on the March 13th. And then on the 17th, from the way I take it, will be the TV cameras in the courtroom.
And we're back.
Calling case 2204-00027.
Oh, yeah, that's not us.
That's
Boomer and Associates, PC, and Matthew.
Yep, we can get rid of that.
Versus
that's not us.
So we're done. We're done then, right? This is a different one?
Yep, different case. They've moved on.
All right. So I thought they were coming back to say something, so I just wanted to make sure. And so
and I just wanted to confirm. So we got the dates is March 13th, 10 a.m. to 1 a.m.
Mm-hmm.
And then again, it looks like it's going to be April 17th, and it looks like they're going to be going for a full day. So people in the chats, if this is something that you're going to want to make sure you write those dates down, guys.
Yeah, write those dates down. It's full day on April 17th and March 13th. It's probably going to be an hour or two, right? Probably.
Yeah, they set aside 3 hours though.
Okay. All right.
Yeah, and we can come back and camp and do it again if y'all want to. I enjoyed this. You
want to do it again? We'll do it again.
I should be in my studio by then and everything. And and what I'll do is, like I said, on this motion to classify private on the 13th, the defense's motion is private. I can't even see what they're alleging. I've been able so far to read the prosecutor and the media's opposition to that. And I've actually done some videos on it, but we can definitely get together and talk about it some more before the thing to give more context. I mean, it's very important stuff. I'm glad I came and started my channel at this time because, these are very important constitutional issues that most people are walking around unaware of, but it could pop up.
And I'm like helping you out a little bit too, and you're helping me.
Thank you very much, man. Yeah, thank y'all. I love this. And so obviously my legal practice, I do freedom of religion, but I'm a big First Amendment guru. I'm really into the First Amendment. So doing the media and stuff like that's very exciting to me. And, obviously I support us having access to all this. It's just hard for me to imagine as a defense lawyer, us out here, like John Bray and these other people, like really putting time and effort into developing these alternate theories and stuff like that. And I mean, court of public opinion. I mean, look how many followers Candace has with her narrative and stuff. I mean, for a defense lawyer, that would tell me that, okay, if I go to trial and advance a story like this, that it has a very good chance of being successful, So it's crazy to me why they want to keep all this private. It seems to me that, the information churning out here, out in the public realm has been really favoring their case. And pretty much every video I see about this issue, like mainstream media video, right? The comments, people, I mean, it's like 95% of people are like, something's not right here. Something's going on. And so I just have a hard time understanding why the defense in that kind of environment is wanting to keep information away from us.
So much tampering with evidence. I agree with you, Susan.
Yeah. Yeah. So they did say that they did what?
Sorry, Greg. I'm just showing a couple comments. You are awesome, Greg.
I will. I'll be back. Oh, absolutely. I'm having fun working with Allie and Chris for sure. So yeah, I will come back. And they did say that they're trying to keep the May preliminary hearing. So that'll be the probable cause hearing where, hopefully all the gloves come off. Hopefully we'll have access to it. That'll be an extremely exciting, action-packed, probably week or two in and around that thing. So let's hope that judge, lets us in on that.
Well, I'm glad having Greg on because he knows all about this stuff. So
yeah, it's been really sort of nice to have Greg talk about this, because up until this point, like, you go and you watch other content creators who are covering like the court stuff, and they're covering it, but they don't have experience. So they're commenting, and I I'm happy for their thoughts on it, but it's not coming from a place of education, because they worked in the field or the business for a while. So I really thank you for coming, Greg, and just giving some more insight from a legal perspective. Because I think when covering the trial, especially with our communities online, we're not always getting like the legal part of it to fully understand what's going on. Like, I wish if Barron was covering it, then we wouldn't have a problem with it. But since and we have these legal questions when we're watching this, it's really good to have someone with your expertise come on and share, especially with the viewers, right? So.
And I think it helps too in this case because there's just a lot of speculation and stuff, right? And that speculation extends into the court process as well. And so I think having at least like a stable foundation on that for like people can, gauge what's kind of real and not as far as normal court procedure and practice, at least helps them put that to rest. So that way we can focus more on the outside facts and what's going on substantively with evidence, right?
So the daughter is not going to be a witness. She was potentially going to be one, right?
No, well, no, I would imagine from day one, they probably worked their case up not to include her because she's the daughter, right? Yeah. And she did testify at the last hearing that they had. They actually went private for a while, if y'all remember, during the hearing for her to testify. And so she did make an appearance. We didn't get to see her, but yeah, that'll probably be the last that we see of her.
You think that's a good thing, or like, what do you think? I think it was a conflict of interest anyways. So
yeah, I mean, I don't have a good feeling about that prosecutor's office, and really just law enforcement in general in that county right now, based upon everything that I've seen. And I covered the other day that they like arrested some guy the day after that was inside the crime tape. I guess they eventually put it up, but for me, it was just they did that to try to scare people like us from showing up and taking pictures and stuff like that. And now that I think about it, because of the amount of independent content creators that probably started to show up immediately, that might have been why they actually paved over the crime scene, to be quite honest with you. So that way, they could do that and put it to bed. That way they don't have to sit there and police it, even though I would argue that the Constitution and due process required that they do that until, defense counsel had been appointed and everything and could get that sorted
48 hours it was covered up. So
yeah, it was actually like 5 days, but still though, it's the principle that like Well, here's another thing that we don't know whether the FBI and these other agencies actually went and did the normal round of forensic testing and stuff like that. Like, I haven't seen any pictures showing them doing that, so I'm assuming that they didn't. And so that's kind of the double whammy.
I seen them there, but I mean, that was what they were there for 4 hours. I guess
Yeah,
I don't know.
I think from the timestamps on the photos we saw, they were there for about half a day ish.
Yeah.
Ish, give or take, you know. So I just find that weird. Like, what kind of forensic analysis could you have possibly done in a crime scene that massive?
Yeah.
Like, come on, you know. And to me, that just seems weird. Like, I'm not a lawyer, you know what I mean? That seems weird to me. Like, there's a lot of areas that you would have needed to investigate and take samples and test from, and I just don't see how you could have done that in the time they had, especially with the local field office being gutted. Like, you know, how did you accomplish a really thorough investigation in that time frame?
Yeah, I honestly don't think they did. And that's, you know, again, if we're living in a normal world, unless there's other evidence implicating Tyler Robinson above and beyond kind of what we've been spoon-fed, in my opinion, it very well might dictate dismissal of the charges, or at least like a very harsh sanction. For instance, the judge could tell the jury, hey, you know, this evidence that was covered over, or this scene that was covered over, you are to assume that that would have been bad for the prosecution's case. So that's also something that the judge could do in that instance. And I think at the very least that needs to be done, because it's hard for me to imagine that he's going to get a fair trial with that whole, like, really the epicenter of the crime scene not having been examined or, you know, measured and for his case. So
she's one of my great researchers. I don't give a damn. Go check her out. Hi, Greg. Love watching court hearings so much. I can't believe people get bored watching court. I love it like a nerd. I love it too. I mean, I just don't get, you know, the lawyer,
the legal jargon.
The legal jargon, yes.
Yeah.
And thank you so much for explaining most of it, because that part I don't understand.
Before we jump to another comment, I just wanted to say, I Don't Give a Damn did a really good, massive deep dive on Mr. Huckabee last night.
Oh, wow. Okay.
Not even joking around. It's great. It's a big deep dive. I think her live was 3.5 hours, but she left no stone unturned and completely exposed him and all his connections for the last decades and decades. So if that's something that's going to interest you, I suggest you hop over and start piecemealing that live of hers, because there's a lot of information there.
Oh, well, thank you. I don't know what happened. It's just a theory, right? I think Allie is right. He was electrocuted and something possibly happened to the electrical box or something.
Yeah, it's possible.
We don't know.
It's possible. And there hasn't been anything to 100% disprove that. So, like, you know, Allie and I legitimately, we have about three theories that we think sort of happened. Like, you know, like the electrocution is sort of one. We're not opposed that, you know, maybe he slipped out the back door. And we're also thinking that, you know, maybe it's possible he was maybe shot from a different location with a different caliber of weapon. So, like, we're still open to all those theories. And, like, if you find us on X, we're one of the only people that you can actually sort of bring any theory to, and we're willing to listen.
Yeah.
Like, a lot of other people are like, nope, I'm firmly in this camp. Don't talk to me about anything. We'll listen to anything. You know?
I mean, anything can happen. Tomorrow, something could change. Somebody could show us something, and then I'm like, wow, you know, I know something is going on underneath here. Like, I was showing you my last live I did with you, the pictures. There was a transmitter on the speaker. Well, what is that? Was he wearing one on himself? Did that do something? I know he had something like underneath here somewhere, and I think they just ripped it off. But that's just my personal opinion. I don't know what they were doing behind the tent, because it was like baking a cake. You know, they're just like, you know, pulling and pushing, and I don't know what they were doing, because when they carried him, I didn't see anything securing his neck or a wound.
Yeah.
Right.
And one thing that we all sort of have to sort of keep in mind when you're trying to figure out what theory you think is most likely, or even if you're trying to come up with something yourself, you got to be able to explain like who you think did it. And then you got to explain the chaos around the tent, all those handoffs, the actions of people, all of that sort of has to be made explainable, or at least make sense loosely. Like I have an open mind. So if you loosely connect things for me, I'll consider that. I'll look into it, you know, especially when we don't have as much info as we need.
We have some comments here. Okay. Thank you so much. I don't give a damn. Most people don't know that U.S. courts, some real evidence can't be used and decisions must be made beyond a reasonable doubt, which isn't always clear.
Yeah. Would that be the difference between admissible and inadmissible evidence, Greg?
Yeah. And as a matter of fact, part of the classifying motions is private conversation that they're having with the media, or from reading the media's response anyways, really centers around a lot of that too. Is like, you know, evidence that's deemed inadmissible, you know, or if we have access to that hearing before the trial and we see evidence that's ruled, you know, that's going to be ultimately inadmissible, you know, what kind of effect does that have on possibly tainting a jury pool? So that's kind of like the issues, or like, you know, well, if we get to see evidence that's ruled inadmissible and we're eventually on a jury, like, is that going to taint us? That wouldn't, you know, because we've had an opportunity to see it, and even though it's ruled inadmissible. So that's kind of getting in and around the debate that's going on with some of the motions. Yeah.
And I think that's pretty valid,
it was
right?
All theater. I agree.
Regardless of what theory you think happened, there was definitely some theatrics going on that day.
Oh my God, there were so many actors.
Yeah. And we actually covered a little bit of that in our last live stream with Greg about deception and who potentially could be behind it, who pulls the strings, and how good they are at pulling deceptions right in front of plain sight, in front of an audience. So that was an episode that we did together. That was on Agency of Massage, as we're calling it.
Yeah.
It was that was a great live.
Yeah, we did well.
I'm trying to keep the lives down to like an hour. I'm trying, guys. Something happened with my captions. I don't know if maybe Dom can help me out. I've helped her out with a couple things for her stream.
We need help now.
I don't know what happened. It's just it's gone. It's like my closed caption and transcripts is gone. So I have to go back and check it out. Hopefully, can you guys see it? Maybe I have to wait till after this is done.
So what we decided to do is we did like a night owl stream last night after Dom had finished hers, like 1, 2 in the morning or something. And what we started to do is stream a horizontal version as well as our lives, so that people could watch on cell phones, right? As well as watch their home TV. But when we did that, for some reason, the closed caption settings disappeared or something. So we're trying to figure that out. We didn't quite figure it out before we went live today. So we're still working on that, guys. We apologize.
No, it's not there. So like when I try to, because I changed my setup, I'll talk to you later about it because, I have the landscape going and I have the mobile phone going and the regular live going. So I have it on 2 things. I don't know, Dom. I will. Oh, thank you so much, Susan. Or wait, hold on. I'm trying to see. She couldn't find me. So she just subscribed. Thank you so much.
Thank you, Susan.
Is that one of your?
Friends? Susan. Yeah, Susan's one of my.
Go follow Greg.
One of Ride or Die subscribers. Yeah.
He's almost at 1,000. Go follow Greg.
I might hit it today. I'll be a hell of a milestone.
Yes.
I think you only needed like 12 or something before we started this.
Yeah.
We could kick a couple people over just to help Greg get over that final.
Yeah, I hope so. Yeah, if y'all have it in you, if y'all could subscribe, the Entheogenic Esquire would be very much appreciated for sure.
Okay.
We will put all his links in the description.
Steve Cameron Productions. Has anyone seen the photo obtained by Barron from the photographer Charles McClintock Wilson showing the damage to his chest? Barron said he got it on the condition he wouldn't release it.
That's not 100% correct.
Well, I have seen it.
But
I cannot. I don't have I don't have it, but I've seen it when we went when we FaceTimed.
Well, wasn't there one of his,
No, it's the one of his chest. It's a chest. He's probably 2. I don't know. I'm allegedly. I don't know. All I know is he showed me one. So
because we've seen one of his chest, and we thought that maybe he had one of his
and
face.
and I don't have it. I seen it. So that's it. I don't know what he has. He probably has more access to the pictures than what I do. I don't have anything. So
he probably paid for it, to be honest.
So I don't know. Like that should be, given to if he has really good pictures, Charles McClintock should give it to the courts, and he probably already did, right, Greg?
Well, Charles McClintock, I would hope, I would imagine.
And I hope he gave the raws over, because the stuff on his website has been touched up a little bit and edited. And I get it, you photographers do that, but I hope at least he sent the raws to the court, because we're not seeing the raws. And that's annoyed Allie and I a little bit, because stuff's been touched up a little bit, and that's what photographers do. But when it's been used for an investigation like this, I think you shouldn't touch anything up. I think you should just send the raws out to everybody. Hopefully the court got the raws. That would be important.
Yeah, and they probably did.
I would imagine he kept a copy of all the originals in this instance, for sure.
Yeah, I don't think people want to see all the gore and stuff online. He's not going to show that. He's already said that on his website. So
yeah.
All right.
It just makes it hard to use those photos, though.
I thought CC only worked in the recorded versions. I can see CC on all your videos. Was my last one last night. People said they couldn't see it. Maybe it's still processing. I don't know.
Actually, that is something that Allie noticed today. Like, even though we did that late stream last night, this morning, the videos still say processing, even though they're on her site and people are watching them. And
yeah,
it still says processing. We're gonna have to look. We're gonna have to look at it again, guys. We're really sorry about that. We know there's
thanks to my mod, Debbie.
Debbie is such a loyal contributor. Can't say enough about Debbie. You're a very good.
I'm 3 subs away. I've acquired four since we got on here. Yeah, 3 subs away from 1,000. The Entheogenic Esquire. If y'all have mercy on me today, it'd be so much appreciated.
Hit the like button and go check him out. He's streaming. Please go check him out. His name is right at the bottom.
Maybe get over there.
You'll get 1,000. He has a small channel. He's trying to get 1,000. You get monetized if you get to 1,000. So if anybody's here,
please go over and sub to Greg. Let's see if we can get him up to 1,000 while we're live here. Let's see if we can get him up to 1,000 while we're live.
That'd be awesome. So grateful.
We're going to start doing the court hearings live if you guys want that.
I'm at 1K.
Oh, right on.
Thank y'all. Oh, I'm so blessed. I'm so blessed, man. And let me say that, like, I know, like, even on your lives and my subscribers, y'all are incredible people that are really dedicated to the truth. And one thing that really gives me faith through all this is I see people from all sides coming together to really crack this open, because I think y'all might agree. I think the answer to what happened here is symptomatic of some larger issues that we're experiencing, probably globally too. So yeah, it's very important work. Thank y'all. I'm so blessed. Thank y'all.
No, like I said, I saw you on Danks. You did a couple of videos.
Thank you, Danks, man. Thank you. Like,
Danks is doing great work, and that's where I saw you from. So I'm so glad that we met, and more lives to come.
Yeah, absolutely. I'll
help you with the monetization if you need it.
Yeah, thank you. And I think today too, like, just with the court dates coming up, 13th, 17th, like, there'll be tons to cover in and around those. And so let's get together and do that. Yeah, it's been going good.
Rundown tonight and I'll make a live tonight and do a little short, like 30-minute, and tell people what happened. Highlights today, because our lives.
I mean, if you need me to, I can pop in later and talk again if you want me to, if that would be helpful.
Oh, I'm talking about you. you make a live stream tonight and do like a rundown.
Okay, yeah. Oh, okay, yeah, absolutely. Yeah, I should probably do it.
Yeah,
I should probably do it for celebrating 1K, anyways.
Yeah, that would be great. And tell me when you're going, and I'll come.
I will. I'll talk to my wife in a bit and see what time. I'll schedule it and let you know.
Somebody else subbed, they said.
Thank you. Great. Yeah, thank y'all. Very grateful.
He's going to be on here a couple more times, because we're going to do the court. Well, we might do another live stream about something else.
Yeah. But that definitely the court stuff. But like I said, it's really good to have you here, Greg, to just sort of, mansplain some of this stuff to everybody. And I say mansplain even though I'm a man, because I still need that education. Right?
Yeah.
Like I'm pretty good with the court stuff, but like, man, I'm not a lawyer.
Yeah, it makes a difference. It does. I mean, there's probably some media people who just cover court stuff constantly who are, pretty well versed, but, especially in cases like this, because there's more like First Amendment constitutional issues beyond your normal, due process, Miranda rights type stuff. It gets into the free speech and public access to courts, which we all have a huge interest in. So, yeah.
Well, I think we're done for today. Because I need to go to the bathroom. I have the bathroom, I had coffees and stuff. So I don't know how other people do it. What are you doing? Stop sending me stuff, Dom. You don't need to send me any supers. You're such a sweetheart.
You just got to send us your hugs.
Greg in Hawaii, Big Island vibes for sure. I see the wood.
Oh yeah, no, but I have a lot of people that I've worked with in my law practice in Hawaii. A bunch of people out there. I want to go. I want to make it out there sometime for sure.
I want to go there too. Who doesn't want to go there?
Yeah. Well, maybe something will happen in Hawaii, and then we'll all get to go there and cover something.
Yeah, man.
I love you too. Yeah, go check out I Don't Give a Dime. She's the bomb.
Yeah, we mentioned her
Greg, I will take you.
Thank you. They said Baron don't break for the bathroom for 3 hours. Yeah, I don't know.
I don't know how he does it.
Yeah.
I don't
Thank
know
you, love and compassion.
Maybe like 4 hours or something.
Yeah, the other night it was 4 hours. He was wiggling in his seat.
She went the longest. Last night was what?
Oh yeah, her live was 4 hours last night.
Oh, but she took breaks. Did
she take a break?
She did.
That's still a hefty stream though. That's a lot of communication. That's a lot of information.
Restaurant manager bladders. Many YouTubers I watched will put on approval music video while they. Okay, well, I'm not that good yet. I don't know how to do that.
Does that mean we got to get like sponsored and we'll just roll like a sponsored ad?
Or like I love Jimmy Dore's one. He has like this nice music. Like it sounds
I like Jimmy Dore.
Sounds Caribbean and you want to dance and stuff. Yeah. I love Jimmy Dore's little we'll be back in a few moments.
Yeah.
I don't know how to do that, guys. I am
Hey, we're still struggling with closed captioning. We'll get that sorted out.
Yeah.
We'll do that.
What's this one? Gary's meltdown crash on Project Constitution.
We watched it live.
About that.
Oh, yes.
We watched it live. Allie and I watched that whole thing live.
That was so weird. I'm not getting into beef with people. This is like, come on, like, can we just like solve this?
Yeah. I don't understand. I just have a hard time understanding like why Gary's been so proactive against like Candace and these other people. I just have a hard time understanding like what the kind of position is there. So yeah, it's weird for me.
Definitely not on the Candace side of things, right? So.
No, he did a live last night. I think they were expecting Candace to do like a full episode, and I think he had a live stream that was going to be like live covering her live stream, but come to find out it was just like a real quick preview video that she aired.
Okay.
Yeah, because she mentioned she's coming back on Wednesday.
Okay.
With a bang, apparently. Apparently, if the preview is what they're going to be airing starting Wednesday.
Back with what? The series,
she's coming back
series.
With her Erica series.
That's going to be interesting.
Yeah.
Well, anyways, guys,
cool.
Thank you so much for
Thank
showing.
Y'all very much. I'm so stoked. Thank y'all.
We will be back here March 13th or probably before then. Just keep an eye on our live streams. I'm going to try to go Tuesday. So I'm going to do like True Crime Tuesdays. I'm going to do Freedom Fridays and Pastor Sunday. So the Freedom Fridays will be all about Charlie Kirk, and then Pastor Sundays, and then Tuesdays I'm going to do completely different. I'm just going to do like cold cases, conspiracy theories, and true crime.
Yeah, so we're trying to bring
Tuesday,
a little
Friday, Sunday.
Yeah, we're trying to bring a little more content. So we're trying to do some cold case files and true crime during the week, like Allie said, Tuesday or Wednesday. Fridays, Saturdays, depending on what's going on, will always be Charlie coverage all day, or all night until we
Trying.
get answers. And we'll always try to do a little something on Sunday to keep our Pastor Sundays going. And Allie will probably always bring some interesting facts of that
Load
as
up
well.
the mystery machine. Yes, I'm going to. I'm going to do that because I was working on
reference.
Yes, I think so.
That's a Scooby-Doo reference, right?
I was working on other stuff before this Charlie Kirk thing happened, but obviously it's on the mainstream right now. So we got to cover it. We got to cover the Charlie Kirk stuff because we can't let this go under the carpet,
under the bridge,
under the carpet, sweep it under. No, like we know this is like really fake and gay. We know it is, so. Right? We know it is.
To quote the girl herself, it's a little bit fake and gay.
And we need to take both of those out, fakeness and gayness out, and we need to bring the truth. So
yeah. Who was it that said the fake and gay the other? I saw that was on a show or something. Somebody went.
And it says it all the time.
Yeah.
Yeah. There's somebody else I saw the other day that went off on it too.
I won't take any fakeness and gayness.
They're like, no offense against gay people. Like,
no. No.
You want to know what? It's just funny. I just remembered an old saying, and Gary and Project Constitution just came up. So with Gary, back in the day, like 15 years ago, there was a saying, "You're a little Gary without the R."
Yeah.
And I just thought it was funny because we were just talking about Gary.
Yeah.
I don't know.
Mention that.
Dom is still in the chat, but somebody subbed her, and go sub Greg.
Yeah, they did. Yeah, thank y'all, man. Yep. I'm smitten.
Just hit 1K.
Yeah, go sub to Dom too. Go sub to Dom.
You should look at Wexner for true crime and the mob. Oh, I would.
Oh, heck yes.
To do the mob.
That's something that I've already been thinking about.
Love it. Ask Chris. I wanted to it's so hard to cover what's happening now in Mexico because your channel will get, you can't show all this violence and bombs.
Yeah, it's getting pretty serious down there.
You can do it on X, but I'd be very careful putting that content onto your YouTube channel unless you want to get struck or taken down or lose your channel.
Yeah, just can't show. There's some things on YouTube, guys, we just can't show.
Yeah.
We just can't.
Yeah, we'll get our hands slapped very meanly. Yeah. Won't be polite.
But I think this is it. They are looking for whoever would happen to the Girl Scout. Oh, yes, I'm going to do that too. I'm going to do that, Debbie.
Yeah. Wow.
I love all that stuff.
Yeah.
Anyhow, guys.
All right.
We are going to go. Cheers to everyone. And we will see you again, Greg.
We'll be in touch. Absolutely. Thank y'all very much. Very honored to be here with y'all hitting 1K today. It's awesome.
Thank you so much.
Remember, Crisis King, guys.
Today. Crisis King.
Yeah, Crisis King.
And I'll see you guys next Sunday or Tuesday, whenever I go. Tuesday, Friday, and Sunday.